Good morning, everybody, from a wet and windy Manchester here. My name's Catherine Hare. I am a professional support lawyer at Forbes Solicitors, and my colleague Katie might be able to see her on screen, hopefully. Want to say
Morning, everyone.
her. So yeah, Katie's based in our Preston office. I'm in Manchester at the moment. So we're going to run through the changes that to employment law and HR that are contained in the Employment Rights Act 2025. The session will be recorded. And if you have any questions, please do just pop them in the Q&A box. You should see that at the bottom of your screen. And we'll deal with questions at the end, if that's okay. Katie and I can stay on as long as needed afterwards as well, if anyone's got any specific questions you want to chat through, or we'll have our contact details at the end. So if you need to contact us after the session, then feel free to do so. So, what is the Employment Rights Bill, now the Employment Rights Act? Now, you may have heard about the Employment Rights Bill, and this was front and centre of the Labour government's manifesto commitments. And the Labour government said within 100 days of them being elected into office, they would lay before Parliament the biggest upgrade to workers' rights in a generation via a piece of legislation, and that was the Employment Rights Bill. Now, the Labour government did achieve that. They got that before Parliament within 100 days, which was no mean feat. The Employment Rights Bill did need to be amended as a result of it, because I think it was quite rushed, but they did achieve that. Um, we've got a picture of Angela Rayner there. The Employment Rights Bill was very much Angela Rayner's brainchild, and it was her baby. She's no longer the Deputy Prime Minister. So she's no longer steering the ship with regards to this bigger upgrade to workers' rights. So the trade unions have raised concerns that may mean that some of the rights that are contained within the Employment Rights Act, which require secondary legislation to be brought into force, may be watered down slightly. We're going to have to wait and see what that looks like. But Angela Rayner not being Deputy Prime Minister will certainly, I think, have an impact on the proposed changes that we're going to go through during the session. So you can see here there are a significant number of employment law and HR changes on the horizon. You can see there in the top left of the screen, hope it's your left, about the day one unfair dismissal rights. And this was contained in the Employment Rights Bill, and this was very much front and centre of Labour's manifesto that everyone, well, all employees would get unfair dismissal rights from day one of employment. Now, when the Employment Rights Bill was going through the parliamentary process, there was a few stumbling blocks, and the House of Lords raised issues with a few things, and really it was the day one unfair dismissal rights that they had a real issue with. Their concern was that there was too onerous on businesses, and that has changed now. So it's going to be 6 months service that's required for someone to have unfair dismissal rights. We will go through this in the session, but just to show that things have changed as they've gone through the parliamentary process. So you may have thought, oh, that I remember reading something about, day one unfair dismissal rights. Things are changing and continuing to change. So I think first top tip is to make sure that if you are thinking about making changes as a result of the provisions contained in the Employment Rights Act, get some legal advice and do your research to make sure that what you thought was happening is actually happening, because things are subject to change. And I think you'll see there in the middle column, single worker status. You may have heard in the run up to the election, the Labour government said, we're going to sort out employment status. It's a mess. And, that was like music to my ears. Sorting out employment status would be absolutely wonderful. Because at the moment we have employees, we have workers, and we have self-employed. But the lines are very, very blurry. Labour said, well, everyone will be a worker unless they're self-employed. That's not in the legislation. That's something the Labour government said they're going to tackle in due course. So, there have been lots of chat about things changing, but some of it hasn't made it to the legislation, like the employment status points, and things may happen throughout Labour's tenure in government. So just be aware of that. So the Employment Rights Bill became the Employment Rights Act in December, the 18th of December 2025. So it received royal assent then. That was the very last session before Parliament rose for the Christmas recess. So it just about made it in 2025. Um, like I said, the Employment Rights Bill had a bit of a torrid time going through Parliament. We thought because Labour had such a big majority, it would just be agreed. The House of Lords, though, there was parliamentary ping pong. The House of Lords didn't agree to some of the provisions within there, but it did. It has now received royal assent. And will everything contained in the Employment Rights Act come into force straight away? Well, the answer is no. Um, And helpfully, what the government have produced is this Employment Rights Bill roadmap. They produced it in July 2025, and it sets out when the provisions in the Employment Rights Bill, now the Employment Rights Act, are going to be coming into force. They give us a bit of a heads up, a bit of a roadmap. What I would say though, is that nothing is straightforward, is it? And this Employment Rights Bill roadmap was produced on the basis that royal assent would be achieved in summer 2025 or early autumn. Like I said, the Employment Rights Bill stumbled through Parliament, so it didn't receive royal assent until December. So what that means is that I think this roadmap may slip slightly, and we can see it already because you can see there that in the roadmap, it says summer to autumn 2025, the government were going to consult on day one unfair dismissal rights. Well, that's not going to happen now because there's not going to be the day one right to unfair dismissal. So that's not going to happen. But you'll see that the bottom consultation there, ending exploitative use of 0 hours contracts, that's not materialised as yet, or it didn't. It's not materialised when I looked over the weekend. It may have materialised today, but from when I last looked, that's not materialised as yet. So things are slipping slightly because it took so long for the Employment Rights Bill to get royal assent. So I think this roadmap's really handy, but I think again we just need to be aware that things are perhaps subject to a bit of change. So when the Employment Rights Bill got royal assent, there were some changes that took place straight away. You can see them listed there, mostly with regards to trade union provisions. So nothing of significance from the respect of significant employment law changes to employment rights. But we will just touch upon a few of the things that change when we look at the trade union section. You'll see then that there's going to be more consultations that are going to be launched. These are being launched and will be launched soon, we think, early 2026. I think first top tip from me is that if you see consultations that are being launched, it's really important that you take part in them because this is the way that we can shape future secondary legislation that will bring all of these provisions into force. I am responding to the consultations on behalf of businesses to highlight to the government perhaps where there's some unintended consequences to what they're proposing. But I think it's really important if you see consultations that you respond to them and really highlight to the government your views on their proposed changes. But you see, it's April 2026 where the biggest changes are going to be coming into force that are going to impact you as businesses. So we've listed them there. We are going to go through them, but just by way of highlight, there's going to be day one rights to paternity leave and unpaid parental leave. Statutory sick pay is going to be payable from day one. And there's going to be the increase in the maximum period of the collective redundancy protective award as well in April. So be aware of that. We are going to go through them. Also in April 2026, the government are very keen to have a fair workplace and to support people with regards to going through the menopause and also with regards to gender pay gap, lessening the gender pay gap. So there's going to be a requirement, well, a voluntary requirement in April 2026 for organisations to kind of put together these equality action plans as to what they're going to do to help individuals going through the menopause in the workplace and reduce the gender pay gap. There are going to be regulations that are going to make these mandatory for larger organisations. But I think first top tip is to think about if you don't have a menopause policy in place, think about putting one in place because Menopause is something that just is cropping up with regards to what Labour's plans are, and with regards to this mandatory requirement further down the line for bigger organisations. So think about menopause policy, think about staff training on the menopause. If you've got uniforms, thinking about how you can amend those perhaps. Um, Encourage open conversations in the workplace. So I think first top tip is that this is going to be coming in at some point. So get ahead of the curve, start thinking about implementing those kind of policies. You'll see then October 2026 is when there's going to be more changes. And for those of you who've been doing employment law as long as Katie and I have, it was previously where we would have changes that were April and October, which were quite helpful because that's when we knew changes were anticipated and we could kind of prepare for those. The past couple of years, changes have been coming in, March, April, May, June, September. There's been all sorts going on. Going back to the April October model, I think is helpful from a business planning point of view and keeping on top of changes. So that's really useful, I think, going forward. But you can see October 2026, there's going to be a whole raft of new changes as well. We are waiting for regulations to bring these into force. So we would caveat that, and we will caveat that when we talk about them. But there's going to be a ban on fire and rehire apart from in very exceptional circumstances. Third party harassment, protection from third party harassment is going to be reintroduced. Employers are going to have to take all reasonable steps to prevent sexual harassment, tightening tipping laws, etc. So lots going on in October. And then just when you thought perhaps that would be the end of it, we get to 2027 and there's all sorts as well, all sorts of things going on in 2027 just to keep you on your toes. And that's when the changes to the unfair dismissal protection are going to be coming into force, changes to flexible working, 0 hours contracts, that's going to be changing potentially if we get the consultation launched. So, lots going on. But I think that roadmap just highlights kind of this, when the changes are going to be occurring that we think are going to be occurring at these times at the moment, but this could be subject to change because a lot of these provisions are subject to secondary legislation to put the meat on the bones of what these new provisions look like. So we are waiting for regulations to kind of understand exactly what these changes will look like going forward. Like I said, there have consultations already been launched. There are active consultations at the moment with regards to workplace balloting, with regards to trade union recognition, for statutory trade union ballots. Like I said, if you see consultations, I think it's really important that you input in those. And like I said, I've been responding and Forbes have been responding on behalf of businesses to make sure that your voice is heard with regards to the proposed changes. So I just wanted to start, I hate seeing pictures of me on these slides. I just wanted to start by talking about the changes to unfair dismissal because I think, from a risk perspective, it's really important to kind of think, what's the worst case scenario, ending up in an employment tribunal and kind of working your way back from that. And at the moment, an individual can't bring a claim against an organisation for unfair dismissal unless they've got 2 years service. Now, the Labour government said that 2 years is too long. We want employees to have day one rights to unfair dismissal. Like I said, the House of Lords said, no, not happy with that. And then there was a bit of bustling, a bit of ping pong, parliamentary ping pong, and they were settled on 6 months qualifying service. So what that means is that from the 1st of January 2027, employees with at least 6 months service will be protected from unfair dismissal. Now, the 1st of January 2027 is the date that the government have kind of indicated is when it's going to be coming into force. We assume that's the case. We've not seen anything to the contrary. So I think it's really important that we start preparing for that now. Because those people who you're recruiting, they're going to be getting employment rights a lot earlier than the 2 years that others may have had, the 2 year service that they've needed to get unfair dismissal rights. So I think it's really important you start thinking about your recruitment processes, make sure you're getting the right people into your organisation. So top tip, I think, if you need to revisit your recruitment processes, if you think, there's you're not getting the right candidates, if you're kind of getting people who are coming and going pretty quickly, it's really important you think about, tightening up your recruitment process, getting the right people into your organization, because it's going to be difficult, I think, going forward, if they have these unfair dismissal rights from 6 months to then move them on if they're not the right fit for the organisation. So think about that. Also, probation periods are going to be absolutely key. So I think, if you've got a 6 month standard 6 month probation period, that's not probably not going to cut it, in the respect of they're going to, at the end of the probation period, they will have unfair dismissal rights. So I think about, perhaps if you want to reduce probation periods, but certainly manage your probation periods. Make sure that your line managers are robustly managing employees through their probation periods. And if they're not a right fit for the organisation, then the right process in place to make sure that perhaps they don't get the 6 months qualifying service. So that's going to be a significant change. Alongside that, this was completely unexpected. It kind of came out the blue. But we think it's going to be the 1st of January 27, when these changes come into force. But the cap on the compensatory award for ordinary unfair dismissal will be removed. So at the moment, if an individual goes to the Employment Tribunal, they win their case, they then awarded compensation. There is a cap on the compensatory award, and the current cap is the lower of £118,233 or 52 weeks' pay. So the lower of those two. Now, they're going to go, those caps. Again, like I said, that kind of came out the blue, really. But I think that's going to be quite significant, because that means that, the Employment Tribunal will become attractive to high earners, because at the moment, because of the compensatory cap, it's not really worth, I suppose, going through the Employment Tribunal process if the compensation is going to be capped. It's going to be difficult to negotiate exits, because at the moment, you've got the cap and you can work back from that. I think it's going to be tricky from a negotiation point of view. And, it may be that if you've got, perhaps older employees or disabled employees, they may be looking for, lifelong losses, maybe. So I think it's really important that, with these changes, that employees are managed effectively. So, think about your line managers, make sure that people are effectively managed throughout the employment life cycle. But certainly, I think, during probation period is going to be absolutely key to make sure you get those right people into your organisation. Again, just looking at this from a risk point of view as well, there's changes to the unfair dismissal protection. There's also going to be an increase in the time limit for lodging a claim at the Employment Tribunal. So at the moment, it's quite a tight time scale. So an individual's got 3 months to get their claim lodged at the Employment Tribunal. The Employment Rights Act will extend that to 6 months. So double the length of time. And we think this is going to come into force in October 2026. Again, like I said, this is all subject to the appropriate secondary legislation being put into place, but we think it's October 2026. So again, I think that's going to mean that people are going to have more time to seek legal advice, to get the funds together, perhaps to seek legal advice. The government have said they estimate that as a result of this change, there will be an increase in claims to the Employment Tribunal of about 15%. I think that's quite a conservative estimate. I think we're going to see a significant increase. Alongside that, you may have seen, hopefully you saw our update on this, that ACAS early conciliation period has been extended from 6 to 12 weeks. From the 1st of December 2025. So this again, it came about quite quickly, and the reason for it is due to the increased pressure on the ACAS caseload. So ACAS are struggling to keep up with the amount of cases. So the early conciliation period has increased from 6 to 12 weeks. But what does this mean? Well, this means from a business point of view, if the length of time to lodge a claim is increased to 6 months, and the early conciliation period has been extended, that means that we may not know a claim has been lodged for a significant period of time. It also means then that the employment tribunals are currently creaking, and they're already listing final hearings for 2028. You know, if there's going to be an increase in claims, it may be that final hearings aren't being listed for a considerable amount of time, from after the from when the incident happened in your workplace. So that means that, memories may fade if we're talking years and years and years until we're going to get to a final hearing. So I think another key takeaway, any employment process that you do, you should always be making notes anyway. The paper trail is absolutely key, but I think it's even more vital now, considering the length of time that it may take to get to a final hearing, because you're not going to remember what your thought process was, so many years ago. So it's really important that you think about making notes of decisions, thought process, who said what when, and make sure it's all accessible. You've got it all saved somewhere. Think about your data retention policies as well. Do they need to be amended to consider this length of time? That's going to be important consideration. And also think about, what if key witnesses leave your organisation during that time, which may very well be the case. If you know you've got a claim that's on its way, or that one's been lodged, someone's leaving the organisation, it's worthwhile speaking to them to explain that you'd like them to come back as a witness in the employment tribunal, perhaps taking information from them as well at the time to kind of get an idea so they can jog their memory too. But yeah, lots to think about with those changes. But I think certainly making sure contemporaneous records are taken of every decision, what your thought process was, is going to be absolutely key. Another change that we think is taking place in April, haven't seen the actual regs as yet, but as far as we're concerned, this is going to be happening. There's going to be changes to SSP, so it's going to be payable from day one rather than day three. Day four. So the three waiting days are going to go. So it means that from the first day of sickness, SSP is going to be payable. So this is quite a big change. And also the lower earnings limit is going to go, and it will be all eligible employees will be able to get SSP, and it will either be the lower of the prescribed weekly rate or 80% of normal weekly earnings. So I think what may happen is, if SSP is available from day one of sickness, we may very well see more ad hoc days sickness. So I think another key takeaway, top tip, is to think about your sickness absence policies. If you've not revisited them for a while, have another look at them, and check that line managers are following through with the sickness absence policies that you've got. So, they are making sure people call in when they're ill. You are doing return to works after every single absence. And if there is these patterns of ad hoc days, that they're picked up and dealt with as appropriate. So we think this is going to take place in April. But we will just need to wait for the regulations just to make sure that that is the case. But I think also make sure, your payroll systems that deal with statutory sick pay, make sure that they can cope with this change too. Trade union reforms. We thought the Employment Rights Bill, now Employment Rights Act, were going to contain significant trade union reforms. They certainly that the Labour have certainly followed through on that promise. There are a lot of trade union reforms that we need to get our head around. We could do a whole session on the changes to trade union provisions, but was going to go through the highlights. When the Employment Rights Act received royal assent, the Strikes Minimum Service Level Act 2023 was repealed. This was the provision whereby there was minimum service levels for certain industries, so for health, education, public sector industries, effectively, so they could keep going through any strike action. That's now been repealed. I don't think it was used a great deal. I think a lot of organisations agreed voluntarily as to minimum service levels, but that's now gone. And what's interesting with the trade union reforms is that I think it's going to make it a lot easier for trade unions to be more active in workplaces, to gain recognition. And I think, a top tip would be, think about, do you already have in place employee forums? Do you have employee reps? Do you regularly meet with your employees to discuss changes in your organisation? I suspect a lot of you already do. And if you do, I think that's great, because then if a trade union does come knocking for recognition, or to have access to workers, which we'll look at, you've already got that really good relationship in place. You've got that secure footing. So I think if you haven't got employee forums in place, it'd be a really good opportunity now to think about having that open conversation with employees. So you've got that good relationship there to build upon going forward. But the headlines with regards to trade union reforms, there's going to be a new obligation on employers to provide a worker with a written statement advising that they've got the right to join a trade union. And that statement is going to have to be given when you give your new employee their Section 1 statement on the first day of their employment. So you give them their contract of employment, you'll also have to give them this written statement to say, look, are you aware that you can join a union? Now, I responded to the consultation on this because within the consultation it said, how often then should this statement be kind of reissued to employees? What's the frequency look like? And I responded to say, well, it's too onerous on employers to be having to reissue this statement every couple of months. That's something else to have to think about. Is it not better just to kind of have the statement somewhere on the intranet or, a sign somewhere? So we'll have to see what the outcome of that consultation looks like. But there is going to be this obligation to provide this written statement. Trade unions are going to be able to enter into what's called access agreements with or where they can come into the premises to speak to staff, but they won't be able to come onto premises as part of an access agreement to organise industrial action. If an employer doesn't agree to the access agreement request, then there'll be arbitration. So it's going to be there's a process in place for that, but just be aware there's these access requests. The statutory procedure for recognition of a trade union will be simplified. We expected that. It's quite complicated at the moment. It's going to be simplified and streamlined. There's going to be more protection and consequences from any unfair practices that employers might try and engage in to avoid recognition, perhaps. There'll be a new right, a new claim that the trade union officials and trade union learning representatives are going to be able to bring at the employment tribunal if they're not given facilities and time off, as is the requirement to do so. And there's going to be a new type of trade union rep, I suppose, a trade union equality representative. There's also going to be a reduction in the notice of industrial action. To be reduced from 14 to 10 days. So at the moment, you've got 14 days of notice of industrial action that's going to be reduced to 10 days. And the period of effectiveness for industrial ballot is going to be extended to 12 months. So it's going to have a longer period of effectiveness. There's going to be electronic balloting, and the protection against dismissal for taking industrial action is going to be extended. So a quick counter through changes to trade unions. Like I said, it can we can have a whole session on this, but be aware of this. A lot of it is open to consultation. There may be changes to this, but I think it's really important that we're aware of these changes that are on the horizon. And then just finally from me, you'll hopefully all be aware that in October 2024, the Worker Protection Amendment to Equality Act came into force, which placed a proactive duty on employers to prevent sexual harassment in the workplace. And you've got to take reasonable steps to prevent the sexual harassment from occurring. Now, when this piece of legislation was going through the parliamentary process, there was an obligation, it was originally drafted, for employers to take all reasonable steps to prevent sexual harassment. The House of Lords again said no, we don't agree with that. The word all is too onerous. What do all reasonable steps look like? No, we're not having that. And they got the red pen and they struck through the word all. The word all is coming back in, unfortunately. So the Employment Rights Act it strengthens the protection with regards to employees experiencing sexual harassment in the workplace, because employers are going to have to take all reasonable steps to prevent that happening. Now, alongside that, employers will also have to take all reasonable steps to prevent third-party harassment. Now, what that means is that if you are an organisation where you have staff who are interacting with the public, thinking about the hospitality sector, you will have a duty to take all reasonable steps to prevent third-party harassment. So third-party harassment was originally in the Equality Act. It didn't really work. we're going to have to see what this looks like, but that's certainly something to be thinking about. And also, sexual harassment is going to be added to the list of qualifying disclosures from a whistleblowing perspective. So it's going to make it front and center with regards to if somebody feels like they need to make a qualifying disclosure with regard to sexual harassment, there will be protection there, and that's going to be coming in April 2026. Now, what's interesting is that the government have acknowledged that taking reasonable steps is difficult. What do they look like? What do all reasonable steps look like? So the government have said they are going to produce regulations that are going to specify what these reasonable steps look like. But they said the regulations are going to come into force in 2027. They're going to materialise in 2027, but obviously the new duty to take all reasonable steps to prevent sexual harassment is coming into force in October 2026. So not quite sure how that's going to work. That's not great. So we're going to have to wait what these regulations look like. But I think the government have given an indication that you're going to have to look at carrying out risk assessments, which hopefully you're already doing with regards to the duty to prevent sexual harassment, but revisit those risk assessments, think has anything changed, keep them up to date. They've got to be living, breathing documents. Think about your policies, think about your training. And I think, we're already, we already do Forbes already did his training for probably a lot of people on this session where we talk about preventing sexual harassment in the workplace, but it was going to be it's a proactive duty. So, like I said, really think now about your risk assessments, and from a third party harassment point of view, you're going to have to think about where's the risk from a third party harassment point of view. Think about commercial terms and conditions. You want to be putting in there, we won't accept third party harassment, and what would the consequence if that happens if your contractors, for example, come onto our workplace and harass our staff. So it's really important to start thinking about this now, get this all in place, because October 2026 is when we think this is going to be materializing. So I will now pass over to Katie and to take you through the rest of the session.
Thanks, Kat. Kat's in control of the slides, so we might have a bit of next slide, please, going on. Right, morning, everyone. Great to see you all. Well, I can't see you all, but great to see how many of you have joined the webinar. So the first thing I'm just going to chat through is 0 hours contracts. This was another big thing the government hung the hat on alongside the unfair dismissal day one right during their election campaign. So what they said was they wanted to end exploitative 0 hours contracts, and for quite a long time we didn't know whether that was a certain category of contracts that they were going to target or whether it was all 0 hours contracts. We know the position has settled at it's looking at all 0 hours contracts, but also these minimum hours contracts, so low hours contracts, preventing you from offering things like a 1 hour contract to try and circumvent the rules that are coming in. So I think you can broadly split it into two different things that you need to be thinking about. The first is that businesses, where they use these 0 hour contracts, are going to have to offer guaranteed hours contracts that reflects the hours that qualifying workers and agency workers have regularly worked over a reference period, which we're pretty sure is going to be 12 weeks. That figure's been knocking around for quite some time now. So that's probably what's going to happen. And then at the end of every 12-week reference period, you'll have to offer those guaranteed hours to the worker. They can decline them, so it would continue as a 0 hours relationship is at the minute, but you have to offer it, and you'll have to offer it at the end of every reference period. So potentially that's every 12 weeks. Workers will be able to bring a claim if you don't offer those guaranteed hours. And there's also a claim being introduced that prevents the manipulation of work patterns. So if a right to guaranteed hours would have arisen, except for the fact that you have deliberately restricted hours that were available in the reference period, then workers will be able to bring a claim about that as well. As I mentioned briefly then, it was extended following consultation to agency workers as well. So this is applying to quite a big chunk of employers' workforces where these contracts are used. So the duty to offer can be contracted out of via collective agreement, it's worth saying, including for agency workers. And in relation to agency workers, the responsibility to make that offer of guaranteed hours lies with the end hirer. So that'll be your business. Um, and the pay offered to agency workers must be no less favourable than their agency terms. Now, the second part of this is related to reasonable notice of shifts. So it's reasonable notice of the shift, the day, the time, the hours, the length of it. And this applies to 0 hours, minimum hours, and workers with no set working pattern. So they'll also be entitled to reasonable notice of changes to shifts or to curtailments. So if you've got a busy leisure business and it's mainly outdoors and the weather is like today, you're probably going to be wanting to send some people home. So in those circumstances, you're going to be looking at paying compensation proportionate to the amount of the shift that's been cancelled. Again, we've not got the details of what that looks like yet, but presumably it'd be some sort of percentage of what they would have earned. Um, in terms of those payments, if it's agency workers, the agency will be responsible to pay them, but obviously there'll be commercial terms in place between your business and the agency, so it's worth checking. I'm pretty sure the agencies will be revising the terms to make sure that you're on the hook rather than them. So that's just worth a point to check. And it's also worth saying that they're only entitled to this payment for sort of cancellation at a short notice if they genuinely eh, would have been expected to work. So if you're a business that offers shifts out to a large number of workers, they probably wouldn't be caught by it. Can we move on to seasonal work next? Obviously, this was a big concern raised during the bill going through Parliament and then the House of Lords that actually there's a lot of businesses out there who engage workers on a seasonal basis, and when we get to the end of that season, there just wouldn't be any work for seasonal workers if they were obliged to offer these guaranteed hours. So there was talk around a 26-week reference period, but I think that's fallen by the wayside now. And what we seem to be looking at is some regulations that allow limited term contracts, um, which I don't know if they're going to be traditional fixed term contracts or slightly different, but obviously fixed term contracts bring with them their own enhanced employment rights. So we'll just have to watch this space on that one. It's going to be open to consultation, and if the basic principle is said to be that if you're offering one of these limited term contracts, then hope that you wouldn't have to offer guaranteed hours at the end of it. And the scope in these regulations, there's going to be apparently to set out further exceptions in relation to sort of these seasonal workers. So as Kat's already said, it's really important that if these issues are going to affect your business, you respond to the consultations once they're running. And just a general point to be thinking now, these changes we're anticipating in 2027. So think about your workforce, think about how it's structured, think about who's engaged on these sorts of contracts. They may even now, over time, they often become part-time employees, and so getting them on the right contracts and T's and C's and thinking about how your business will be able to operate in 2027 whilst we're still in 2026 and you've got a chance to change things. Flexible working, we had some changes over the last few years. We're now, it's already a day one right. What's going to change is you'll only be able to rely on one of the 8 statutory reasons to refuse a request where it's reasonable for you to do so. We're seeing that word reasonable a lot throughout all of this stuff. it's what we're going to get is regulations to specify what steps you must take in order to demonstrate that you've been reasonable. So we're probably almost verging on some sort of statutory procedure. Again, it's also not clear whether it's reasonable refusal from the employer's perspective, the employee's perspective, a mixture of both. So we need some clarity on that as well. Um, what I would say is you probably are largely dealing with flexible working requests reasonably already because employees, there's so much other protection they have around it. Flexible working requests tend to be linked to some sort of protected characteristic and so on. So they already have protection and largely the flexible working requests I see, employers are reasonable in dealing with them. So we'll need to make sure we comply with any statutory steps that you must take to demonstrate reasonableness, but hopefully it won't be too far removed from what you're already doing. The second point I'd make is penalties for breaching this statutory flexible working regime are 8 weeks pay capped at £5,600. So whilst that doesn't get you off the hook for sort of discrimination claims or anything if you get it wrong, the actual penalty if you get this little discrete point wrong is max £5,600. I'm going to move on to the Fair Work Agency next, which is an executive agency of the Department for Business and Trade that's going to be set up. So it'll be created administratively and won't sort of have its own legal entity, but the Secretary of State will be able to, they have enforcement powers and they will be discharged via the Fair Work Agency. And it's really intended to have some real teeth, this. It's coming in April 2026. Obviously, it's going to take some time, I imagine years, to be properly established and functioning. But the extensive powers that it's going to benefit from, I think, are indicative that it's seen as a key part of labour market enforcement going forwards. So it's bringing together all of these different functions that are listed on the slide. So it's going to be enforcing things like national minimum wage compliance, SSP, tribunal penalties, labour exploitation, modern slavery, employment agency rules, and for the first time, we're getting statutory holiday pay enforcement, which could be a bit of a minefield for some businesses, I would think. So they're going to have powers, these enforcement officers, they'll be able to enter your premises, obtain documents, inspect electronic records. They're even going to be able to get warrants to enter homes and do those things too. So it's something to be taken really seriously, in my opinion. If you're familiar with some sort of national minimum wage inspection by HMRC, it will operate like that regime does, but across all these other enforcement areas. So if discrepancies are found, if non-compliance is found, then they'll issue a notice of underpayment, as they do in the minimum wage regime. That's payable within 28 days. On top of that, you will be fined 200% of whatever the underpayment is. That's payable to the Secretary of State. And then on top of that, we now are seeing that the Fair Work Agency will be able to recover costs of enforcement from employers. So its remit is huge. It's very punitive. And it's coming from April 2026. It'll also be able to, like it says on the slide, bring claims on behalf of workers where they don't want to bring a claim. So that's an interesting concept, and we'll have to see how that pans out. Just on the holiday pay point, we're getting new obligations on employers to keep certain records relating to annual leave and pay. So they're listed here on the slide. But if you think about that in the context of what we've just talked about in relation to the Fair Work Agency, it really strongly encourages you to. You may already be doing this by virtue of record keeping anyway, but just go away and check you've got records that meet these criteria. There's no set format as such. What the legislation says is they may be created, maintained, and kept in such a manner and format as the employer reasonably thinks fit. So go away, check you're doing these things and keep them for 6 years. Check your data retention policies as well and make sure that they're in line with this requirement. And just note that failure to do so will be a criminal offence punishable by fines. So if you're taking this back to, if you're HR, taking this back to board of directors, there's some really punchy stuff here that will really start to bite if you're not compliant with these points and also the other points on the previous slide that the Fair Work Agency will start to enforce. A little bit lighter now. Some changes to family leave coming in. These are some of the first changes that will be coming in April 2026. So we've got day one rights to parental leave, to paternity leave, and also looking at widening parental bereavement leave to a more general bereavement leave right from day one, and also pregnancy loss, including before 24 weeks. That bit, it doesn't look like will come in until 2027. Going back to parental leave, they'll get the right from the 6th of April, but just be aware that they can start giving notice that they want to take that from the 18th of February. So that's very soon. So you might start to see some of that in the next few weeks. In terms of paternity leave, it says on the slide, obviously, what the changes are. What has been confirmed the government published a raft of fact sheets. I think I'm right in saying it was last week, Kat, which are all available online. We can circulate the link with the slides. It might be worth a quick look at them. But within one of those, they have confirmed that whilst it's a day one right, there will still be the 26-week qualifying period to receive statutory paternity pay. So the other point I'd make is where we're getting sort of rights where, so for example, the bereavement leave one, what you need to also be mindful of is, I mean, a lot of businesses will give bereavement leave as a standard. It doesn't necessarily need to become a statutory right. What it does do, though, is then gives them other rights. It gives them other rights. For example, automatically unfair dismissal. They'll be protected from that if you look to dismiss them because they've been on bereavement leave, etc. So sometimes they look like simple changes, but they actually have wider ramifications. We're also getting enhanced protection for pregnant and new mothers. So, as it says, the Act will strengthen protection against dismissal for pregnant employees, mums returning from maternity leave, and actually the Act contains provisions to extend it to all forms of statutory family leave, so things like adoption leave as well. So this relates to any dismissals which aren't redundancies, which are linked to either pregnancy, maternity leave, pregnancy or maternity related illness, or any claims for maternity benefits. So it captures everything, doesn't it? And if you think of that in the concept of some of the non-disclosure stuff I'm going to come on to, it's very, very broad and strong protection for women and other people taking family leave going forwards. We've just had a consultation close on that, so hopefully we'll get a bit more information, a bit more meat on the bones soon. The next one is tips and gratuities. I'm just going to skip over this because I appreciate it doesn't probably apply to a lot of businesses. So in October 2024, there were some quite wide-ranging changes which employers had to comply with. So it was all about making sure that workers receive tips and gratuities and service charges in full and that they're allocated in a fair and transparent way. And it brought in sorry, it brought in claims that workers could bring if that wasn't happening and to access records and so on. What we're now going to see, and we think this is October this year, is that the Employment Rights Act will introduce new obligation on employers. So if you're already doing tipping, um, divvying up, you'll have already done your policy and so on. But anyone new to tips will have to consult about a tips policy that they're going to introduce before introducing it. They'll have to review it once every 3 years, and they also will be required to make an anonymised summary of the consultation they undertook available to workers. So just some slight changes to be aware of if it applies to your business. Right, collective redundancy consultation. So I'm sure many of you will be familiar that the current position is if you're proposing 20 or more redundancies at one establishment within a rolling 90-day period, that you must go through a process of collective consultation and the various obligations that come with that. And if you get it wrong, there's a protective award of up to 90 days pay, which is payable. Now, most tribunal awards are compensatory in nature. This one is deliberately punitive. It wants to punish employers for not doing what they should have done. Now, what's going to happen is that is going to go up to 180 days from April 2026. So that's potentially, it already was quite a big punitive liability, and it's going to double. So that's the first point. Then this one establishment point, they are looking at introducing a new threshold test that it's not only where there's 20 redundancies, but also we think it's going to be something like the lower of 10% or 100 employees in total across workplaces or sites. So it's this concept of aggregating redundancies across your business. So I think where you've got multi-site operations, you need to be thinking about implementing tracking systems so you know where redundancies have taken place, and also thinking about the fact that actually some small little redundancy exercises will need collective consultation. That's not coming in until 2027, we don't think, so a bit of time yet. And again, there'll be a consultation running soon, and I would strongly encourage you to air your thoughts to the government once that is live. The other just point I wanted to make is this legislation redundancy captures termination and re-engagement on new terms where you're forcing it through whilst it's still lawful for you to do that. And that leads us on to our next slide, which is on fire and rehire and fire and replace. So you may recall in 2024, we got a code of practice which sets out, in detail what the government expects you to do if you're in this sort of scenario. That was following on from the big fire and replace P&O Ferries debacle, which gained an awful lot of very negative publicity. So we've got this statutory code. That isn't law. It's something the tribunal will take into account if you don't follow, and then they can uplift tribunal awards accordingly, a bit like the ACAS code operates. So as it stands, it's lawful to do this, but increasingly high risk from a reputational and industrial relations point of view. What's going to happen going forward is it's going to become unlawful, except in a very limited number of situations. So it'll be automatically unfair to dismiss someone if the reason is that they didn't agree to your attempts to vary terms and conditions, or because you intended to employ or engage someone else on varied terms and conditions to do substantially the same role that they were doing. So it relates to pay, working hours, pension, shift times and lengths, time off rights, and others to be confirmed. We think that might be changes to benefits that might feature there. So pretty wide-ranging changes to terms and conditions. If outside of those categories, you will still potentially be able to force through changes. It wouldn't be automatically unfair, but your normal unfair dismissal um, tests would kick in, um, and the tribunal would. Sorry, I keep getting little pop-ups on my screen that are really distracting. Your tribunal will be taking into account your reasons, consultations, and anything you offered the employee in return for agreeing to the change, um, in deciding whether it was a fair decision. So this is coming in from October 2026, we think. Although yet again, the consultation is yet to start. I thought we'd have seen some consultations sort of up and running straight after coming back from the Christmas break. So it's quite surprising we're at the end of January and the miles behind where they should have been. So whether all these dates will get nudged back, we don't know, but I think it's best to work towards them for now. Um, the other point, so there is this limited exception. So if your business is in absolute dire straits financially, then there may be an exception that you can rely on. But other than that, these dismissals will be automatically unfair. And I know when I know when we were going through the Employment Rights Bill, going through Parliament and so on, people were saying, "Oh, quick, get a flexibility clause in your contract." Yeah, they're not going to be something you can rely on if that's what you did at the time. Right. Lastly, from me, we've got restrictions on an employer's ability to enforce NDAs. I mean, I think this is massive, and it was a really late and complete surprise addition to the Employment Rights Bill as it was going through Parliament. So what's going to happen is there will be restrictions on your ability to enforce NDAs, non-disclosure agreements, sorry, which prevent workers from making disclosures that relate to harassment and discrimination. So that's huge. It's relevant harassment and discrimination, which includes all your direct and indirect discrimination, things around disability, reasonable adjustments, pregnancy and maternity leave, gender reassignment, harassment, sexual harassment. So it's huge. And again, these fact sheets that were published last week, there's some examples in that fact sheet of where the government thinks this sort of thing might be relevant. So two examples given were one of your workers witnesses the employer harassing a customer. So, so you couldn't enforce an NDA in that situation. And another one is a harassment that a worker suffers at the hands of your client. So they really are wanting to clamp down on this sort of secrecy around discriminatory behaviour by employers and third parties. So as it says there, does it say there? It's not clear when it'll come into effect. Like I say, it wasn't in the roadmap. I don't think we've seen anything yet, other than the fact that they're going to do some consultation on it. And they've also talked about regulations might define what they call accepted agreements, which would allow NDAs to be entered into at the employee's request, having had independent legal advice. That's the position in Ireland. So that would seem a sensible sort of approach to take to it, and that would still enable us potentially to still be using settlement agreements in ways that we do now. But if you just think of it, or if you just think of it all in the round, so if you think of that additional maternity protection, and we can't dismiss anyone who's had some maternity related absence or something like that. Often businesses would use settlement agreements to resolve those situations, and potentially going forwards, that may not be possible. So that's just something to be thinking about as well. I know that we've touched on lots of tips as we've gone through. We've sort of pulled these together in the last couple of slides. So things like reviewing T's and C's, it's going to get really difficult to change those going forward. So the sooner the better that you tackle that. And any contractual policies. If you've got contractual handbooks, you really want to be thinking about making those non-contractual because you're not going to be able to even change simple policies going forwards once the fire and rehire stuff comes in. Reviewing probationary period clauses, we're suggesting 5 months maximum to clients. You probably even want a 3 month review and then a 5 month maximum. Training line managers, time and time again, the things we see that come across our desks, it's line managers that have made a mistake or ignored a problem or not addressed something. And so this is going to be more critical than ever. And we are doing loads of it at the moment, training for clients. Tightening up recruitment processes as well, like Kat said, to make sure you're hiring the right people in the first place. Then statutory sick pay arrangements, have a look at those and your payroll systems, reviewing sickness absence policies, your sexual harassment stuff, that has got to be pretty near the top of the list. I would say it's going to be a huge change, particularly in certain sectors. Amend family leave policies, engage in government consultations, and then thinking about practical steps. We're going to get more ET claims. Um, so you want to be thinking if you've got risk situations already, take draft statements. If people are leaving your business, who've been involved in something acrimonious, take draft statements before they disappear, because it's going to be even longer now before you become aware of claims than it used to be. And again, training managers on contemporaneous notes and all that sort of thing. Fair Work Agency compliance with their regimes is going to be massive. You might want to do things like holiday pay audits and things like that, national minimum wage audits, workforce audits. So this is thinking about, again, 0 hours workers and whether there's more appropriate ways to engage them or alternative ways. And then just a few other points about, just business planning and can you cope administratively as all these changes come in and financially. And then, as Kat said about the trade union stuff, which would be interesting to see how that plays out over the next few years. But and I know businesses that are doing this already, build up strong relationships with your workforce now, set up employee forums, take those seriously, invest the time now, and it'll save you trouble in the long run, I would think. Have we got any questions coming in? Have you?
Yes, I think we have, but I can you see them, Katie? Because I am sharing the screen, so I can't see them as yet. Can you see them?
We're getting some questions about are all these changes definite? Yes, but I'll caveat that with, but we're waiting for regulations on all of it. So we're in a more certain position than we were, but we've not got the devil in the detail on a lot of it yet, I think.
Yeah, so we've had commencement regulations for the paternity, the day one paternity and parental leave. So that's going to happen in April. But yeah, unfortunately, because a lot of the provisions need secondary legislation to bring them into force, we are waiting for those to materialise. So yeah, I think the roadmap's really helpful. I would have loved the roadmap to be updated.
Yeah,
That was on my Christmas wish list, but it
I don't know
didn't.
why
It
they
didn't
haven't done
happen.
that. Yeah.
I know that would make much more sense because I seem to spend my days just trawling through the government websites just to kind of see if any commencement regs have been materialised or when consultations are going live. They all just kind of appear on a very ad hoc nature. So yeah, so I would say, look, the roadmap is there. That's what the government are working to. So I think there's no harm in preparing for that. But yeah, we're going to keep you updated as and when things occur. Um,
I think
but
that's what
yeah,
I would say. By nature, employment lawyers are very reactive, and we're going to become even more reactive, I think, over the,
yes,
the coming months, and as soon as we've got more that we can tell you, we will be putting sessions on, and it might be more tailored to a certain area, like Kat touched on before. You could do a whole session on the trade union stuff. So
Mm.
we will be doing that, and we will be very proactive in doing that. Um, yes, we'll be sending a copy of the presentation out, Vicky. So look out for that in your inbox. Um, Someone has asked Kat, and I haven't
Mm.
seen anything about this that I can recall. Is parental leave, is there any statutory pay entitlement to that?
No, I think it would be unpaid parental leave as far as I'm aware. Yeah, it's
I've
not
not
going to
seen that
be.
that's changed.
Yeah, it's not going to be paid. It will be unpaid, but it's just the change being from day one, as far as I understand it.
Someone's asked, have we heard anything regarding maternity leave and pay? I'm not aware anything's changed.
No, I've not heard. No, nothing changed. Like I said, this the enhanced protections against dismissal for those returning and during, but nothing about pay as yet that I've seen.
Yeah. And then someone's asked about, did you say make employee handbook and policies non-contractual? I would suggest that you do that because, well, and also check that often when you see contractual handbooks, they've got terms in them that should be in a contract and not a handbook. And then the handbook should be policies that are non-contractual that you can change as needed. So yeah, I would recommend that. It might be that you need a complete redraft of both sort of your template contracts and your handbook in order to get to that point. Often it's more efficient to start from scratch and pull in your key terms and policies than try and make your contractual handbook non-contractual and move it all to your contract. Um, and then someone's asked, has a decision been made on the value of SSP? Will it be going up by a larger amount than it usually does? I've not seen.
No, I don't know what they have announced the rates for April. I think we've got an update ready to go out actually on that. So I don't know off the top of my head, but that has been announced. So we are going to be sending out an update on that. But certainly there's going to be financial implications out there from it being payable from day one. And obviously with the low earnings limit being removed as well, that's significant. Um, so yeah, but we are sending an update out on the updated statutory payments shortly.
I think that's everything that I can see on these questions. I don't think I've missed any.
Right. Well, we have okay, got Katie's details there, so that's fine by me. But yeah, if you do want to contact us, please feel free to do so. We're happy to answer any questions. And like I said, we will keep putting on these sessions as and when developments occur. But I think, the roadmap is there, it sets out what the government's plans are. So I think we certainly, from the key takeaways we've given, she really needs to start planning now, getting ahead of the curve, I think is the best way forward.
Oh, there's lots of thank you messages coming through. That's lovely.
So,
We hope
thanks,
it was
everyone.
helpful and we hope to see you again on future ones.
Thanks, everyone.